Hi, I'm Julie Kinkoff, and today we are going to give you a video update on a recent development in employment law. The one we're going to talk about today is an important change to New Jersey's law against discrimination. This change applies to all contracts that are entered into, renewed, or modified on or after March 18th, 2019. Governor Murphy just signed a law on that day that fundamentally changed employment contracts and settlement agreements, and we need to talk about what those changes are. Two common terms in those agreements are now considered against public policy and unenforceable in New Jersey. The first one has to do with confidentiality provisions in settlement agreements. Under the changes to the law against discrimination, it is now a violation of New Jersey law for a settlement agreement to contain a provision that quote, has the purpose or effect of concealing the details relating to a claim of discrimination, retaliation, or harassment. Now, this is in response to the Me Too era, but it is not limited to sexual harassment or sexual discrimination claims. It includes all claims that are brought under the New Jersey law against discrimination. So all of the protected classes under that statute. It means that settlement agreements can no longer conceal the details. Now, that term is not very well defined. It's generally understood to mean the basis for the actions that led to the claim of discrimination, and not necessarily the fact that it was settled or the amount of the settlement. Settlement agreements also must have bold, prominent notices in them that state that although the parties may have agreed to keep the settlement and underlying facts confidential, such a provision in an agreement is unenforceable against the employer if the employee publicly reveals sufficient details so that an employer is reasonably identifiable. So that notice needs to be in bold and prominent notice in any settlement agreement going forward. Think of it similarly to the notice that needs to be in the front of your handbook if you're in New Jersey. Now, this is a big deal. This is a big deal because settlement agreements often include confidentiality provisions. If you have pending discrimination claims, you need to recognize that you will no longer be able to keep the details of those claims confidential. That may affect a lot of settlements in New Jersey. The other change has to do with employment agreements. Employment agreements can no longer include any provision that would waive substantive or procedural rights or remedies. This is an attack on arbitration agreements. It does not use the term arbitration agreements, and it's unclear how this law will be read as it relates to the Federal Arbitration Act. But for now, if you have in your onboarding documents or in your employee agreements arbitration provisions or something like that, those are now considered violation of public policy in New Jersey. And as with all changes of the law in New Jersey and the law against discrimination, there's an anti-retaliation provision in the law. You cannot retaliate against somebody who refuses to sign an agreement that violates the law. So what does this mean now? It means if you have pending litigation, you need to recognize that confidentiality cannot be part of a settlement. You also need to be careful if you're drafting a settlement agreement not to have that agreement based on New Jersey law if you're a New Jersey company, because that could be read to include these provisions. And you need to review your onboarding and your employment agreements to make sure that they do not include arbitration agreements or similar limits on remedies or procedural safeguards. So I hope you have found this helpful. If there are other issues that you would like us to address in a video update, please let us know on Twitter at WG Employment Law or send us an email at jkinkoff@wglaw.com. Thanks.